The EPA obviously had a different point of view. Frederick Liu, assistant to the Solicitor General, represented the EPA. He began his statement with a bit of legal sleight of hand.
Mr. Chief Justice, and may it please the court. San Francisco's opening brief makes one and only one argument, that Section 1311B1C authorizes only effluent limitations. This court, however, already rejected that argument in National Association of Manufacturers, and in any event, the statutory text and history make clear that Section 1311B1C also authorizes other limitations. San Francisco is therefore wrong to argue that limitations like the ones challenged here are never okay.
To understand the sleight of hand, we need to look at the statute in question. Title 33 of the United States Code, Section 1311B1C reads, "Not later than July 1st, 1977, any more stringent limitation, including those necessary to meet water quality standards, treatment standards, or schedules of compliance established pursuant to any state law or regulation under authority preserved by Section 1370 of this title, or any other federal law or regulation, or required to implement any applicable water quality standard established pursuant to this chapter." Mr. Liu and several of the justices will spend a lot of time on this question of any more stringent limitations, and whether or not any of those limitations are limited to effluents. Lost in much of these arguments is the fact that the law in question is part of Section 1311, effluents limitations. I was rather surprised by how much time both attorneys and the justices spent on what seems to me to be a simple point that the law they kept referring to covers effluent emissions.
Rather than pursue an individualized challenge to the limitations in this case, San Francisco has put before this court only a facial challenge, that all limitations that prohibit discharges based on their effects on water quality are invalid on their face because they don't fit the statutory definition of effluent limitation. Because that argument can't be squared with this court's precedents or the statute itself, this court should affirm.
So in the EPA's mind, San Francisco's argument falls short. Notice how Mr. Liu says it cannot be squared with the Supreme Court precedent, and then with the statute. It shows just how twisted the legal system has become, placing the opinion of judges above the law. But there's another twist to this story.
I want to be clear about the sort of information that we're missing that made it impossible for us to impose anything other than these generic limitations. It's not information about the water. It's information about San Francisco's own sewer system. We're talking about where do the flows go? What's the conditions of the pipes and the pumping stations? How does the system respond to wet weather events? That's the information that we've been lacking for the past 10 years and that we asked San Francisco to provide as part of the long-term control update. Without that information, we're basically flying blind as to how we're going to tell exactly what San Francisco should do to protect water quality.
Does anyone else find it convoluted that a city needs to report about their sewer system to a federal agency in order to comply with the state's water regulations? Why is the federal government tasked with enforcing state water standards? And why is the EPA acting as the architect for California water quality? That's not all.
I don't understand, the bad old days is when we had water quality standards, right? People didn't know what they were supposed to do, how it was going to be allocated, sort of a problem of the commons, and they put in the permit system. And I think the danger here is that you're going back to the other system because one gives more power to you because you don't have to tell the people who are discharging what they have to do or not. You can sit back and also you don't even have to allocate among many different polluters who's responsible for what. So what prevents you? I know you touched on a couple of things in response to Justice Thomas, but I'm not sure that was significant limitations from saying, as you're doing here, we're going to go with water quality standards because that's maybe harder for the people with effluent, but it's a lot easier for us.
Apparently, when the Clean Water Act was first put in place, cities like San Francisco were given quality standards to maintain by the EPA, but they didn't know how they were supposed to do that. This is what led to the convoluted permit system currently in place. Chief Justice Roberts asked, does the permitting language merely go back to the water quality standard of the past, and is the EPA doing this to make their lives easier?
No, it's not easier for us. In our ideal world, we would have perfect information about how San Francisco's system works. And based on that information, we would be telling San Francisco things like, reroute flows from X to Y, upgrade your pumping station at Seacliff, increase the storage capacity of your West Side storage facility. We were unable to include limitations of that tailoring in this permit because San Francisco deprived us of the very information we would need to do that. We have no interest in putting in generic provisions like this when we have the information available to supply more tailored information, more tailored limitations. And that's what it's precisely because it's so much easier to enforce a more tailored limitation.
Apparently, in EPA's perfect world, they could micromanage San Francisco's wastewater system, telling them exactly what they needed to do, right down to which sites needed what upgrades. Is anyone else thinking about Big Brother? Justice Kavanaugh had an interesting exchange with Mr. Liu about the ex post facto aspects San Francisco was claiming.
Problem is, you can go after an individual entity like the city of San Francisco based on the past when they didn't know what the relevant limitation on them was and seek retroactively without fair notice huge penalties, including criminal punishment, based on something that was they didn't know what they could discharge or not discharge. Correct? I mean, a lot of what you're talking about in response to the Chief Justice is here's things that could help going forward.
Right.
You're suing San Francisco separately for a lot of money based on a standard that they had no idea that, at least that's the theory. That's the theory in your position. Your position would allow that.
I don't.
Yes, it would.
I mean, the Bayside complaint is Exhibit A for why what you said is not going to be true. The standards that are violated in those cases are numeric water quality criteria.
The standards, the generic limitations contain water quality standards that you don't know as an individual entity what you need to do to comply with.
San Francisco has not pointed to any instance of that.
Justice Kavanaugh, and in fact San Francisco, is pointing to generic limitations. So when Mr. Liu points to a single instance that included numeric water quality criteria, it seems to miss the point. If Mr. Liu is correct and San Francisco has not pointed to a single generic limitation they need to comply with, he might have a point. I haven't read all the case documents, so I'm not sure. And Justice Kavanaugh did not bring up an instance.